Good morning. Happy Tuesday. So, one of the slow boys in my chat who has an opinion on everything and believes his opinions are correct, who hilariously blamed the USS Liberty incident on the crew of the USS Liberty, which I thought was amazing, apparently doesn't understand the issue of the anti-SLAPP motion for attorney's fees. And so I understand that some of my audience isn't retarded, and I apologize to those people, but I am going to break this down in excruciating detail because apparently Fraud or Troll and Wayne don't understand shit about fuck, and those are legal terms. So, Fraud or Troll filed a SLAPP claim, strategic lawsuit against public participation. He filed a SLAPP claim against DMA. DMA filed an anti-SLAPP motion, a motion to strike, and included in that motion to strike, the anti-SLAPP motion, was a request for attorney's fees based on winning the motion to strike. So those are the two pending issues. Immediately following the filing of the motion to strike, immediately the same day, Fraud or Troll files a motion to voluntarily dismiss his counterclaims. So there's two things pending in front of the court: a motion to strike, the anti-SLAPP motion, and a motion to voluntarily dismiss the claims. Comes down to the court ruling on it. The court denies as moot the motion to strike because the court grants the motion to voluntarily dismiss the claims. Now, the stupid people are going to remember that there was a request for attorney's fees in the motion to strike, but that was attorney's fees based on winning the motion to strike because it was filed before the request to dismiss voluntarily the counterclaims. So when the motion to strike was dismissed as moot, the court was like, well, you didn't win your motion to strike, but while attorney's fees aren't guaranteed, you can file a motion for attorney's fees. And if you read the case that the court cited, in that case, the court said, it was a California Superior Court case, I believe. The California court said, it's basically presumptive that if they dismiss in California, it would be their cross complaint or their complaint with the SLAPP cause of action in it. If they voluntarily dismiss that while there's a pending motion to strike, an anti-SLAPP motion, it's presumptive that the party filing the motion to strike is the prevailing party. It's presumptive that the party that voluntarily dismissed their SLAPP cause of action is that they did so because they couldn't achieve a litigation advantage because they were going to lose, and they knew they were going to lose, and that's why they dismissed it. So you're entitled to attorney's fees. The presumption is you're going to be entitled to attorney's fees. And the federal court knows this. Now, when the court denied the motion to strike and the attorney's fees based on the motion to strike as moot, it still said, you get another shot at this if you want it, just file your motion. Which is a court's way of telling you, you're probably going to get it. I mean, maybe Fraud or Troll can pull some magic rabbit out of his ass to show that he did gain some litigation advantage, but the presumption is he didn't. You still got to file a motion, though, because there's no pending motion. Because I denied your motion to strike as moot with the associated attorney's fees, and because I granted their motion to voluntarily dismiss, which did not have attorney's fees associated with it, there's no pending attorney's fees in front of the court. So file your motion, Randy. File your motion, DMA. That's what the court said. because there was no motion for attorney's fees based on the voluntary dismissal pending before the court at that time. That's why the court said that. There was no motion for attorney's fees based on the voluntary dismissal pending before the court. There was a prior motion for attorney's fees based on a motion to strike, the anti-SLAPP motion, but that had been denied as moot because the court granted the voluntary dismissal. You can't give the motion, you can't strike it and let them voluntarily dismiss it at the same time. They're mutually exclusive. That's why the motion to strike was moot. There's no once the court granted the voluntary dismissal, there was no counterclaim left to strike. So again, the way it would happen if the case doesn't settle is Randy will prepare a motion for attorney's fees based on the voluntary dismissal of the anti-SLAPP or voluntary dismissal of the SLAPP claim while there is a pending anti-SLAPP motion. He's going to allege the presumption, which is in all the California case law on the issue, is that Fraud or Troll did not gain any litigation advantage and realized, because he filed his voluntary motion to dismiss or motion to voluntarily dismiss the same day as the motion to strike was filed, he knew he wouldn't prevail, and that's why he voluntarily dismissed it. And that's the presumption. He would also have to show the lodestar to prove his attorney's fees, et cetera, because he's not entitled to whatever attorney's fees he claims. He's entitled to reasonable attorney's fees. And then the burden would shift to Fraud or Troll, who would have two things that he would probably try to show. Number one, that he did gain some sort of litigation advantage by filing the SLAPP claim and then dismissing it. Probably won't be able to show that. That's a hard thing to show because he didn't gain anything by it. There's no evidence in the record that I can see, and I don't watch his channel, so who knows? He talks way too fucking much about his case. Maybe he did elucidate the public, his viewership on what litigation advantage they gained. But if you take what he's saying is true, that his then attorney said that he would pay the attorney's fees associated with it, that's a pretty strong admission that you didn't gain an advantage. And that your attorney, who probably knows better than you do, the likelihood of having to pay the sanctions, the attorney's fees associated with the motion to strike, thinks that the motion to strike or that attorney's fees are going to be awarded. Now again, I don't know if Vondran agreed to pay Fraud or Troll's attorney's fees for that. I would doubt he did. He might have. Got something stuck in my throat. I doubt he did. He might have, but I'm going to press X to doubt because Fraud or Troll doesn't always tell the truth. It doesn't mean he always lies, but he certainly doesn't always tell the truth. So the burden again would shift to Fraud or Troll to try to prove that he did gain some litigation advantage, and then also he'd probably attack the lodestar that Randy would have prepared, showing that actual attorney's fees paid to people in practice in this area are lower, blah 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 blah. Right? So that is the way that motion would shake out, and not having seen the motions, but assuming that Randy is competent, because he's been competent so far and prepares a competent motion for attorney's fees based on prevailing on the anti-SLAPP motion, which again was denied as moot, but it was dismissed as a result of the anti-SLAPP motion, or it was voluntarily dismissed in reaction to the anti-SLAPP motion. So assuming Randy's competent, and assuming Lou, who I know that's not his name, I don't fucking care, assuming Lou is competent, which I have no reason to believe he's not, I would still suggest that if I had to bet today, not having seen any pleadings, I'd bet that Randy would prevail, and he would get some attorney's fees. Probably less than what he asked for, but more than what Fraud or Troll wants to pay. And then another comment that I wanted to respond to wasn't made by Wayne or Fraud or Troll. Fraud or Troll, thankfully, is shut the fuck up in my comments, which I appreciate because, again, it's not that I don't like people commenting in my comment section, but people who are engaged in active litigation should not be commenting on their active litigation. Whether I like you or not, that's my best advice to you. But somebody said that, well, several people said, essentially that there's no settlement yet, and it's unlikely it's going to settle, and blah, 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 blah. Well, Lou drafted the notice of tentative settlement, whatever he called it. You don't put that time and energy in if you don't have an agreement on the basic dollar amount. In my experience, you don't do that unless you have a basic agreement on the dollar amount. It's not saying that we're going to start settlement negotiations. It's saying we're really close. And so, we want to hold off on everything else. We don't want to incur any more attorney's fees until we finalize this, because it's probably going to be finalized. So the likelihood of this settling at this point is incredibly high. I'm not saying it can't fall apart. That is possible. But I would bet my next 3 months of earnings that it's going to settle. Don't take me up on that, because I don't want fraud or troll just to nuke it, just to own me. It wouldn't be in his best advantage to do this just to own me, certainly. But lawyers, remember, Lou is a professional. Randy, whether you like him or not, is a professional. These guys are competent attorneys. They do things competently. I have not seen anything incompetent out of them. Just because Lou filed a motion to dismiss for form nonconvenience that is unlikely to succeed doesn't mean that he even expected it to succeed. He might have been doing it for some other litigation purpose, to put pressure on Randy. There's a lot of reasons why attorneys file motions that aren't guaranteed to succeed. That's one of my biggest faults as an attorney is I don't file motions unless I think I'm going to win. And a lot of attorneys do, because they get advantage. They put pressure on the opposing party who's having to pay attorney's fees to fight these motions, and sometimes that in and of itself can pressure your client into settling for terms worse than what they could get at trial, because they just want the motion practice to stop. They want the bleeding to stop. So that's a failing on my part. I'm not nearly aggressive enough on that, and I admit it. I am just a first-year family law attorney, though, and hopefully I'll get better once I get into my second year, which is coming any day now. Any day now, I assure you. But these guys are competent attorneys, and they would not have put this work in. They wouldn't have filed this notice to the court of the tentative settlement and putting off everything else. And Randy above all, because Randy's going to get those attorney's fees. It's not going to go to DMA. Randy's going to get the attorney's fees. 99.9999999% sure that in whatever agreement they have, Randy gets the attorney's fees, if any attorney's fees are awarded. So Randy's going to get those. Randy has no reason to stay everything pending settlement. He has every incentive to file his motion for attorney's fees, because he is very likely to succeed on it. So again, there's no reason for them to file this unless they have a close to completed settlement where they figured out who's paying who, what, and how. So sorry to burst everybody's bubble, but that's the way it is. So thanks for watching. Have a great day.